Good afternoon. My name is BRafoss. I'm coming to you from Saskatoon, and I'm here to do a presentation on the legal history behind the Trans Mountain Pipeline expansion. You may be aware this is being challenged by Indigenous groups, and I hope to walk you through that a little bit and speak directly to some of the precedents that the First Nations have been able to use successfully to stop the pipeline to date. Yeah, you see here a map of the pipeline. The pipeline is in yellow, the expansion. Sorry, the existing pipeline is in black, of course, and the expansion is in yellow. So it goes pretty well from Edmonton right down to Vancouver, and goes accordingly through many First Nations territories. As you may be aware, most Crown land in Canada has been ceded by Indigenous people. Here is a map of the treaties across Canada through peace and friendship treaties by and large. You'll also notice that that treaty-making process more or less stops at the British Columbia border. Most of British Columbia until recently was unceded territory, and that, in my view, gives Indigenous people an additional tool in which to fight some of these incursions into their land. In the past few years, and well, especially since 1999, there has been treaty making happening in British Columbia, though, most notably with the Nisga'a Agreement in northwestern British Columbia. That was a self-government agreement that sort of set the stage for some additional negotiations. According to the BC Treaty Commissioner, there are now 200 Indian bands in British Columbia. 65 of them are currently participating in some form of self-government or treaty-making process. And that represents a little bit over 52% of the Indigenous population in British Columbia. So it's a bit leading, perhaps, in the sense that these agreements have not been concluded, yet it does seem to indicate an interest on the part of Indigenous people to engage in the treaty-making process. And as we know, one thing about the Indigenous people of Canada, they are basically peaceable people in the sense that they're quite open to treaties. So that seems to be happening in British Columbia. Again, because 52% have agreed, that means 47 haven't. That means almost half of British Columbia is unceded and are not even in negotiations. This map is a good illustration of that. It shows the territories that are claimed by First Nations. So the ones in orange are the ones that are unceded, and the ones that are in green, if those are the colors coming across to you, are the ones where there is a current agreement. So in the northwest of British Columbia, for example, you will see the Nisga'a Agreement there being highlighted. Again, Indigenous people have been using the fact that these are unceded lands in their challenges to the Trans Mountain Pipeline. This pipeline proceeded by way of an order in council that followed a National Energy Board inquiry into the feasibility or the impact of the pipeline. Indigenous people and others, though, challenged that order in council in court and were ultimately successful before the Federal Court of Canada. And in doing so, they made a number of key arguments, in my view, that were useful in achieving the results that they were looking for. The first decision was the Haida Nation case in 2004 in British Columbia. This was a case about forest permits being granted in Indigenous territories, and that was taken to court as well by the Nisga'a Nation, and successfully so. This is the case that established that there was a duty to consult Indigenous people when developing on their lands. And not only to consult, but to accommodate their concerns where that was possible. The court went on to say that where the incursion or the impact of the development in their territory is greater, there is an increasing duty to accommodate. So this is a very important concept as we look ahead to the Trans Mountain Pipeline, not only the duty to consult, but the accommodation issue as well. The second, this is the Haida Nation, by the way, which is just off the coast of British Columbia, as you probably know. And the second case related to the Chilcotin territory. This is unceded land again. They challenged, again, I believe it was a forest permit or some kind of a mining permit in their territory. And this was a landmark case in 2014 that determined that Aboriginal title existed and continues to exist to today, has never been ceded, in other words. This was the case as well that looked at the issue of not only the territory where the Indigenous people mainly reside or work, but the broader territory that they've possessed or covered sort of in time immemorial. So this was a very important case as well because it then transposed this duty to consult onto the Chilcotin territory as well and strengthened the argument ultimately before the Federal Court of Appeal. There was, of course, one other important legal instrument that Indigenous people had, and that was the UN Declaration on the Rights of Indigenous People. This was adopted by the United Nations in 2007 and ratified more recently by the Government of Canada in 2016, although it hasn't been implemented yet by way of legislation because it died on the order paper of the most recent Parliament. It is likely to be resurrected. And in the meantime, you might be aware that the government of British Columbia has introduced a bill to confirm or apply the United Nations Declaration to the situation in British Columbia. This is a very important instrument because it clarifies and in fact even extends this idea of duty to consult to one of consent and says that where there is development on Indigenous nations, there's a duty to receive from that First Nation free and informed prior consent or free, prior, and informed consent. It's worded differently in different contexts. So this takes that duty to consult issue one level higher, in my opinion, to duty to consent. Now, again, this isn't law in Canada, but certainly was persuasive before the Federal Court of Appeal. This is, in essence, where Canadian law is going when it comes to Aboriginal law. And so this was a great advantage to them as well. So what happened? Well, Chilcotin title was recognized, of course. We have the UN Declaration, and ultimately the... Sorry, I'm having a little technical problem here. Trying to get to there. There we are, the Federal Court of Appeal decision. This was taken forward by one of the First Nations, several First Nations actually, as well as the City of Vancouver and the City of Burnaby and some environmental groups as well. And you probably all know that eventually the order in council that approved the pipeline expansion was struck down by the Federal Court of Appeal in a fairly strongly worded decision. The chief judge or the authoring judge, I guess, of the Federal Court of Appeal, Eleanor Dawson, was pretty clear that this duty to consult that was referred to in the Haida Nation case means more than the federal government simply listening to Indigenous people and taking notes. Being a note taker, I think, was the words she used. She again relied on this duty to accommodate as well, that the government must do something about those concerns, not simply listen to them. And so she struck down the order in council, and that effectively stopped the pipeline from proceeding. Just go up ahead a little bit here. Yeah, the federal court said that the government must be prepared to accommodate, prepared to make changes in the plan, thereby accommodating some of the concerns of the Indigenous people. So the government decided not to appeal that decision, but rather to go back into a second round of consultations, and they appointed former Chief Justice Frank Yakibuchi to oversee those further consultations with Indigenous people. That happened over the winter of 2018-2019, and in June of this year, the federal government approved a second operating permit to allow the pipeline to proceed. Now, if you look at the government website, they actually are proceeding with the pipeline. There are a number of developments there, and I'll show you that in just a minute. But meanwhile, there has also been a second application to now the federal court asking them to review whether the second set of consultations met the duty to consult as identified by the Federal Court of Appeal. So that'll be the subject of this next round of hearings. We'll see what the court says. And meanwhile, it looks like the pipeline is proceeding, as I indicated. This here is a map published by the Government of Canada that actually speaks to the issue of the pipeline proceeding. So there hasn't been a full stop on the action of the government. I guess maybe that'll be part of the application process before the federal court, will be to get basically an injunction to stop the development from proceeding. The Indigenous people clearly are not happy. They believe that the government listened better, perhaps, but they really didn't make any accommodations. In fact, they say it was a foregone conclusion that the pipeline would proceed, and that's what they're challenging this most recent order in council on the basis of. Meanwhile, it's interesting. The federal government posted on their website that there's a fourth level of consultations going on after the first two, of course. Now this one. There has been an application by some Indigenous leaders to actually buy the pipeline and to build it. And the government has said, as part of these fourth consultations, it's talking to these organizations. One of the leading ones is called a Reconciliation Pipeline, or Project Reconciliation. The principals are a number of Indigenous people, and they argue that Indigenous people should have a piece of this action now, that they've been on the sidelines for so long that it's time for them to get involved. So that is kind of an interesting development. I sense that the federal government wants to unload the pipeline because of the political challenges that it's facing for them, and there's perhaps an easy out there for them in terms of Indigenous organizations who want to become part of the action. So a summary, duty to consult, of course, is key, but that includes accommodation as well. Where the impact is the greatest, there may have to be consent too. Developers and government ought to take notice of this trajectory of the courts. There have been a string now of decisions that have gone in favor of Aboriginal rights, and it seems pretty clear to me that any developer wishing to start a project on Indigenous territory has to go back to the first step and start by consulting with them in a meaningful way. So I hope that helps. Sorry I'm a bit long. There's my references, and they'll be included in the package that's filed online. I hope that was of some use to you, and thanks for the opportunity to hear me. Bye for now.